Hello dear aspirants, welcome to Epitome IAS. So we are doing the UPSC PYQ analysis and today's topic would be the continuation of judiciary and the judicial system in India under the Indian polity. So let us start with the today's class. So the next question, with reference to the Constitution of India, consider the following statements. Statement 1, no High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. Statement 2, an amendment to the Constitution of India cannot be called into question by the Supreme Court of India. So what the statement 1 is saying, no High Court has the jurisdiction to declare any central law to be constitutionally invalid. They are technically saying that this High Courts, they don't have power to declare any laws which are made by the state legislature, whether it's invalid or not. Okay, they are saying High Court does not have the power to declare the laws of the state legislature invalid. So technically this is wrong. Why? The High Courts along with the Supreme Court has the power to declare any law invalid. Okay, so this statement is a wrong statement. Statement 2, an amendment to the Constitution of India cannot be called into question by the Supreme Court of India. The thing is, see here, this statement is actually, doesn't make any sense. Why? Because the Supreme Court of India, what is the major function of the Supreme Court of India? Okay, it is the guardian of the Constitution, right? So whenever the Parliament makes any law to check whether this particular law is constitutionally valid, who checks the constitutionality of any law? The Supreme Court will do, right? So this statement is saying any amendment by the Constitution of India cannot be called by question by the Supreme Court of India. No, if that is the case, then the Parliament will literally rewrite the whole Constitution based upon their whims and fancies. Okay, so this particular statement is a very absurd statement. This is a wrong statement. Why? Because the Supreme Court of India has the power. Okay, whether it's a constitutional amendment or whether it's a normal law, act, laws, anything, the Constitution, the Supreme Court of India has the power to review. Okay, whether it's constitutionally valid or constitutionally invalid. Okay, so we can say both these statements are wrong. D, neither one nor two is the correct answer. High courts in India possess the power of judicial review under, this thing and examine the constitutionality of laws by the central government parliament. Okay, high courts also have the, power to whether check the constitutionality of the parliament's laws, not only the state legislature's law, also the parliament's law. Okay, there is a brief period, yes, during this time 1977 and to 1978, for this around 2-3 years, what happened was this particular power was restricted. Okay, they said the High Court does not have the power to, review the laws made by the parliament. But what happened then, after some time, this thing was actually repealed. Okay, so now currently we say the judicial review of the parliament's law is also lies with the High Courts along with the Supreme Court of India. Okay, next, the Supreme Court of India is the ultimate guardian of the Constitution. As I already told you, Supreme Court of India is now also called as the guardian of the Constitution of India, right? So it has the authority to review the constitutionality of the amendments made by the Parliament along with other laws and acts made by the Parliament. Okay, then this power ensures that amendments don't undermine the basic structure of the Constitution. Yes, as I already told you, if this power is not there, then Parliament would have literally rewritten the Constitution of India. Like totally different Constitution of India will be written. Okay, so the Supreme Court clearly said you can amend. You have the Parliament have the power to amend the Constitution of India. Okay, but there is a check here. What is that? The basic structure of the Constitution, without disturbing the basic structure, without changing the basic structure of the Constitution, the Parliament can amend the Constitution of India. That's what the Supreme Court of India said. Okay, The basic structure is a concept developed by the Supreme Court of India. Okay, this was not given by the original constitution. This was actually the Supreme Court of India came up with this particular term in Keshwananda Bharati case, right? Then refers to the core principles that define the Indian constitution. Example: federalism, secularism, judicial review. Like there are a bunch of number of things which comes under the judicial review, and there is no any specific judgment which has covered all the things which are basic structure of the constitution. No, in different cases, during different cases, the Supreme Court of India, whenever it feels that this particular provision is the basic structure of the constitution, that particular provision will be added under the category of basic structure of the constitution. So if they are asking, it is clearly mentioned, basic structure is clearly mentioned. No, it's not clearly defined. Okay, basic structure is not clearly defined. What comes under the basic structure is actually decided by the Supreme Court in different cases, and it's actually evolving with time. They'll be adding more of the provisions to the basic structure of the constitution. And what they are saying is, this is the basic structure. Let's say these are the pillars which hold our constitution. So these parliament has the power to amend the constitution without impacting the basic structure of the constitution. Without changing the pillars, you can amend the constitution, but you should not touch or you should not change the basic structure of the constitution. With reference to the Gram Nyayalaya Act, which of the following statements are correct? As per the Act, Gram Nyayalayas can hear only civil cases and not criminal cases. Statement 2. The Act allows local social activists as mediators or counselors. So if you see here, they are talking about the Gram Nyayalayas. Okay, these are also one of the important topic which is actually related to the judiciary. Okay, we will be talking about the alternate mechanism. Okay, so this is one of the alternate mechanism, Gram Nyayalayas. You will be also reading, whatever related facts and concepts, you have to read it. Okay. So the first statement says, as per the Act, the Gram Nyayalaya can hear only civil cases and not the criminal cases. This statement is actually wrong. Why? Because this Gram Nyayalayas, they have the power, to make judgments on both civil cases and the criminal cases. But only check here is, they can have only these petty cases, small cases which does not require big legal complications. It does not have any legal complications. Very petty cases, small cases, these Gram Nyayalayas, they can consider. Even though it's a criminal case, even though it's a civil case, no issues. Both civil case and the criminal case can be considered by the Gram Nyayalaya. So this particular statement is a wrong statement. Then statement 2 says that the Act allows local social activists as mediators or counselors. Yes, this is true. So these social activists, they will be acting as a mediators or the counselors. Okay, in case of judge, we have judge, right? Judges to make judgments in the courts. But here we'll be having mediators or the counselors, and this local social activists, they can be become the mediators. Okay, why this particular thing is there? This is an alternative mechanism, okay, for speedy trial. If you remember, we know that, right? We have a high number of pending cases in India. Okay, so through some of the alternate mechanisms, we are trying to reduce these pending cases. Let's say these are some petty cases, small cases. So if they are going to the court for these small cases, it will be wasting the court's time also. And those people who are going for the court, it will be wasting for their time also. It will be taking years, right, to come up with the whatever judgment or everything. So because of this particular alternate mechanism, there are different examples for that. One of the example is Gram Nyayalayas. So the thing is, this they have came up with this particular thing. Okay, so this statement is a correct statement. Option B, only 2 is the correct statement. So the Gram Nyayalaya Act 2008, okay, this particular act empowers these village courts. These are like local courts, okay, in a remote villages, let's say these remote areas where the people are not able to, reach the courts. Okay, there in the local remote areas, these courts will be functioning, and they'll handle both civil cases and the criminal cases. But only there is a twist. What is that twist? That is, they can handle both the civil and criminal cases, but they can handle only petty cases, small cases. They cannot go for some legally complicated cases. Okay, so the act specifies types of cases under the Gram Nyayalaya's jurisdiction. And these typically minor offenses, like small offenses, I don't want to give the examples. The minor offenses and disputes, these are listed in the schedules of the act. These are actually mentioned in the act itself. And these type of cases are taken up by the Gram Nyayalayas, and they'll be, giving their whatever judgment. Okay, the Gram Nyayalayas wouldn't handle major crimes, let us say murder. Okay, these are some of the major crimes. So they can't handle the major crimes. Instead, what they can do, they will be handling small petty cases. Okay, and complex legal matters. So obviously, complex legal matters are the cases to be taken care by the codes, other codes, okay, which are specifically made for that particular function. Okay, role of social activists, as I already told you, these social activists, they can be act as the mediator or the counselor in this particular Gram Nyayalayas. So you can read this. Let us go to the next question. Who or which of the following is the custodian of Constitution of India? A basic question, okay, asked in 2015. Who is called as the custodian of the Constitution of India? Tell me the answer. Who is called as the custodian of India? Just now, before like 2 minutes, we were discussing this thing. It is the Supreme Court of India. Supreme Court of India is also known as the custodian of the Constitution of India. Okay. Then the Constitution itself established the Supreme Court and vests with the power of judicial review. The Constitution of India gave the power to the Supreme Court, to judicial review, power for the judicial review. Okay, the Constitution of India itself gave this power, and this power allows the court to examine the constitutionality of the laws passed by the parliament and the state legislature. Both the laws passed by the parliament and the state legislature, the Supreme Court will be checking whether it is constitutionally valid or invalid. Okay, so this is the thing, this is the power of judicial review which is given to the Supreme Court of India. Also, this power is given to the High Court of India, but technically the Constitution, guardian of the Constitution, this thing is actually used to mention the Supreme Court of India. Okay, then by interpreting the Constitution and striking down the laws that violate it, the Supreme Court of India safeguards the Constitution's supremacy and ensures that all laws comply to with the principle. So this is important. By interpreting the Constitution, obviously there is a lot of ambiguity in the Constitution. There are very difficult terms, right? And many cases, whenever we are doing the PYQs, whenever there is a statement that this particular term is defined by the Constitution of India, this particular term is mentioned in the Constitution of India, I almost say most of the cases the statement is going to be wrong. Why? Because most of the cases the Constitution of India does not define what is, like we saw example right now, like this proven misbehavior, incapacity. So what this actually means, they have given these terms, but what these terms actually mean, who will give the answer? The Constitution though does not provide the definition for these terms. So it becomes the duty of the Supreme Court of India to interpret the Constitution of India. Okay, whatever the constituent assembly, our forefathers, what was there in their mind, what they wanted, to be in the Constitution, when they are mentioning these terms, what they wanted, what would be the meaning that these our forefathers have been thinking in their mind. So this interpretation is done by the Supreme Court of India. So that's one of the major function of the Supreme Court of India. And apart from that, the second thing is to maintain the constitutional supremacy. So if you see in India, we have constitutional supremacy. That is, the constitution is the law of the land, and no one is above the law of the land. Parliament, government, Supreme Court, people, no one. So constitution is the law of the land. It is the supreme authority. The government is not the supreme authority. The parliament is not the supreme authority. So whatever the function of the government should function in accordance to the constitution. It cannot go against the constitution because that is the supreme authority. Constitution, written constitution is the supreme authority. To let us say our forefathers, they wrote the constitution, they just gave it to us, they went. Obviously they are not there, right? So now who is going to protect this particular authority? If if the government is easily able to amend the constitution, if it is easily able to overthrow the power of the constitution, then how will the authority of the constitution is maintained? It is maintained because, or how, by the Supreme Court has given the power to maintain that constitutional supremacy. So whenever other organs of the government, let us say the parliament, is making any law which is against the constitution, the Supreme Court will simply struck down that law, cancel, no, cancel, it's gone. And let us say it some other, let's say executives or legislative, anything, whenever someone is acting non-constitutional, especially the government's organs, the Supreme Court of India will be able to check them. Okay, and obviously there is another provision. If the parliament is sitting and changing the all the provisions of the constitution, it's rewriting a completely new constitution, that is also a possibility, right? In that case also, the Supreme Court has the power to tell, obviously, this basic structure of the constitution. Supreme Court said, parliament or a state legislature, you people can't amend. Obviously, parliament only has the power to amend the constitution, not the state legislature. In case of the amendment of the constitution, I'm telling you, the parliament, okay, the Supreme Court says to the parliament, you can amend the constitution, you have power to amend the constitution, but you cannot change the basic structure of the constitution. If you are changing the basic structure of the constitution, if you are amending the constitution, okay, completely, like changing the basic structure, then I will struck it down. That's what the Supreme Court says. So the parliament will eventually cannot go against the constitution of India. Okay, so that's the thing. So you can read this. You can read this as well. Other institution, president, prime minister, Lok Sabha secretariat, other powers. You can read that. Next question. The power of Supreme Court of India to decide disputes between the center and the state government. Advisory jurisdiction, appellate jurisdiction, original jurisdiction, writ jurisdiction. So the Supreme Court of India has these, types of jurisdiction: advisory jurisdiction, appellate jurisdiction, original jurisdiction, and what, writ jurisdiction. Okay, we'll be reading, every what are the cases which are under these types of jurisdiction. Tell me the examples. What are the examples for advisory jurisdiction? What are the examples of appellate jurisdiction? What are the examples of original jurisdiction? And what are the examples of writ jurisdiction? Let us say who is going to, tell the correct answer. Okay, without seeing. Obviously, you can't go and check your book or Google it and then, tell. You have to, without existing knowledge, with your existing knowledge, try to recall. Okay, try to answer and let us see who is going to, write it correctly. Okay, so if you see here, this particular, whenever there is a dispute between the center and the state, this particular jurisdiction of the Supreme Court comes under the original jurisdiction of the Supreme Court. In original jurisdiction, those cases or those types of jurisdiction that are actually original to the Supreme Court, it is only exclusive to the Supreme Court. Those are comes under the original jurisdiction. For example, this center state, or let's say some states versus center, or let's say one state versus dusra other state. Okay, then obviously the high court cannot come and do that. You know, that's why it is the original jurisdiction of the Supreme Court. Option C is the correct answer. I want you people to interact in the comment section. Tell me the answers. Okay, then I'll understand whether you are able to understand whatever I'm saying or not. Okay, then original jurisdiction. refers to the Supreme Court's authority to hear and decide specific types of cases for the first time. So this cases for the first time directly goes to the Supreme Court. Okay, not goes to any other subordinate court, directly goes to the Supreme Court. What are these examples cases? First is under Article 131. It grants the Supreme Court of its original jurisdiction. Okay, the Supreme Court has a original jurisdiction mentioned in the Article 131 of the Indian Constitution, directly given in the Constitution. So, what are these? First, union versus one or more state. Union versus one state, or union versus one or more state, two state, three state, whatever. So, these cases directly go to the Supreme Court. Then, central government and any state on one side versus one or more state on other side. So this is also one of the interesting case. Let us say the Union of India along with one of the state or some of the states versus some other states. Then also this will be a original jurisdiction given to the Supreme Court of India. Then these disputes can involve various matters like division of resources, interpretation of interstate agreements, infringement of the state boundaries. Okay, examples. These are some of the examples. Next question. The power to increase the number of the judges in the Supreme Court of India is vested with President of India, Parliament, Chief Justice of India, Law Commission. Tell me the answer quickly. Okay, before seeing the explanation, tell me the answer. Let us see who is going to tell the answer correctly. So they are asking who has the power to increase the number of judges in the Supreme Court. Okay, so the correct answer is it is the Parliament. Okay, not the President, not the Chief Justice of India, not the Law Commission. No, they don't have power to increase the number of judges. Okay, of the Supreme Court of India. Tell me how much judges currently, how much judges are there in Supreme Court of India along with the Chief Justice of India. Tell me who. Let us see who is going to tell it correctly. Okay, so the power is with the Parliament. The Parliament has the power to increase the number of judges in the Supreme Court. Then, yes, you can see here, and it is actually mentioned in Article 124 of the Constitution. It empowers the Parliament to determine the number of judges in the Supreme Court. It states that the Supreme Court shall consist of Chief Justice of India until Parliament by law prescribes a larger number of not more than 7 on other judges. Okay, so that's what is given in the Constitution. Tell me how much currently how much judges are there in the Supreme Court of India. Okay, then this is the legislative authority. Parliament as the supreme legislative body has the authority to enact laws pertaining to the organization, and these are some of the they have given what are the options. Regarding the options, if you want you can read, it's up to you. Next question. What is the provision to safeguard the autonomy of the Supreme Court of India? Statement 1. While appointing the Supreme Court judges, the President of India has to consult the Chief Justice of India. Statement 2. The Supreme Court judges can be removed by the Chief Justice of India. Okay, this is so funny, right? Statement 2. Then statement 3. The salaries of the judges are charged on the Consolidated Fund of India, to which the legislature does not have to vote. Statement 4. All appointments of the officers and the staffs of the Supreme Court of India, they'll be appointed only after consulting the Chief Justice of India. Okay, first statement says that appointing, whenever you are appointing the Supreme Court judges, the President of India has to consult the Chief Justice of India. Yes, this is what is mentioned in the Constitution of India. Obviously it is not they have mentioned consultation, only consultation, but technically it is binding on the President of India. Okay, so while appointing any judges of the Supreme Court, the Chief Justice of India has to consult, the President of India has to consult the Chief Justice of India along with the senior most judges. Okay, tell me how much senior most judges. Okay, again another question. Try to answer with your existing knowledge. Then the Supreme Court judges can be removed by the Chief Justice of India. Is that true? Can the Chief Justice of India has the power to remove the Supreme Court judges? in one of the previous question we were seeing, right, the Supreme Court judges can be removed by a impeachment process, and the process is actually held in the parliament, both the houses of the parliament. Okay, so this statement is a wrong statement. Okay, then the salary of the judges are charged on the consolidated fund of India. We read this every time. Okay, to which the legislature does not have to vote. Why this provision is given in the constitution? Because when there is a provision, let us say this particular judge's salaries, let us say it has to be voted by the parliament, then they will be acting in a disadvantage to the judges. Let us say the Supreme Court is not favoring the movements of the parliament. It is going against the parliament. If the parliament is acting unconstitutional, then there is no freedom for the judges of the Supreme Court. That's why the Constitution of India provides for this particular provision. It will ensure that the judges or the Supreme Court function independently. Okay, it will be charged upon the consolidated fund of India. Directly they'll be removing the money and putting in their bank account. Okay, but this particular thing is not voted by the Parliament of India. If you see in the budget, you'll be seeing most of the things they'll be in the budget itself, they have to vote. And those things which are charged upon the consolidated fund of India, they are not put to vote in the Parliament of India. Okay, so that's why this particular statement is a correct statement. Then statement 4, all appointments of officers and staffs of the Supreme Court Supreme Court are appointed only after consulting the Chief Justice of India. Is it possible? Tell me, all like officers and staffs, only the Chief Justice, only the judges of the Supreme Court before the appointment, the Chief Justice of India should be consulted, okay, by the President of India. But all the officers or staffs, it's not possible, and it's not even mentioned in the constitution, obviously. So this is a wrong statement. No, not all officers or all the staffs before appointment they should be consulted with the Chief Justice of India. No, that's not correct statement. We can eliminate this option. So what is the correct answer? 1 is correct and 3 is correct. So option A, 1 and 3 is the correct answer. So here we can see, while appointing the Supreme Court judges, the President of India has to consult the Chief Justice of India. Okay, and this is given in Article 124 of the Indian Constitution. And this consultation process ensures the executive branch, that is the President, and also the judiciary, both executive and the judiciary, they'll be involving in the appointment of the judges. Okay, then salaries, obviously according to Article 125 of the Constitution, they are charged on the consolidated fund of India. They are not put to vote in the parliament. Then you can read this, I already explained you. These provisions collectively serve to safeguard the autonomy and independence of the Supreme Court of India. Okay, and that's it. So that's all, students. We have done with this particular today's topic, today's video. We'll be continuing with the judiciary, and we'll be trying to complete the topic in one of the next video. Okay, so that's all, and whatever question I asked you, try to answer it. Let me check it. Okay, then thank you, students. We'll be seeing in the next class. Okay.